a political agenda will make a decision that is inappropriate in this circumstance. I also know that this thing is working its way through the courts and likely will end up at the Supreme Court. So we'll have to wait for the final decision there. But I do believe that this law will go into effect on January 1 and that it will save lives across the state.
That's Governor J.B. Pritzker earlier this week reacting to questions of if he's concerned that there will be an injunction put on the state's gun ban registry after a Southern Illinois district judge heard the case on Tuesday down in East St. Louis. Of course, we reviewed some of that yesterday, and the transcript is available. So we'll touch on exactly where we're at with that case, but also with the status in the Seventh Circuit Court of Appeals with that denial that happened earlier this week for an en banc or full court review of that case, which had a whole bunch of different litigants involved, but also some of the latest action out of the U.S. Supreme Court when it comes to two different cases. The one out of Naperville, and also the request for a action from Dan Calkins's case in the U.S. Supreme Court, that being denied yesterday. So a lot to tackle here. Appreciate you guys being with us. But let's go ahead and hear what Governor J.B. Pritzker had to say earlier this week when he was asked about the Joint Committee on Administrative Rules and also about the potential for an injunction from the Southern District of Illinois federal courts. Here's the governor earlier this week answering questions from reporters in the Chicago area.
Again, the idea here is to make sure that people are registering their assault weapons, and they are. Thousands and thousands of people have registered their assault weapons. We can expect that to continue. I think as you get closer to a deadline, I think it's true for all of us that when we're faced with a deadline, right, you start to work, more significantly toward the end of that deadline than you do at the beginning of it. And we're seeing that more and more people are signing up and registering their weapons.
So the governor, of course, being asked about the rules, and the rules aren't finalized. We had September 15th, JCAR, the Joint Committee on Administrative Rules, filing emergency rules months after the January 10th enactment of the Protect Illinois Communities Act that banned the sale and possession of 170 different semi-automatic firearms and any magazines that hold more than 10 rounds for rifles and more than 15 rounds for handguns. Being found in possession of these things can lead to a Class 3 felony in certain instances. I think the magazines, it's a misdemeanor a charge if you're found with high-capacity magazines. So the rules for the registry were supposed to, be in place before the October 1st deadline. Those rules did not get put into place until September 15th on an emergency basis. Didn't go through the typical rulemaking process of, months ahead of time before an enactment. You've got proposed rules, deliberation around those rules, modifications of those rules, plenty of time for public comment on those rules. That normal rulemaking process didn't play out until all of a sudden September 15th, 2 weeks before the October 1st date for the registry to open by law, and Illinois State Police filed emergency rules that go into effect immediately. Then last week, state police, after the registry had been open, and you've got thousands of people registering firearms, about 0.25%. Again, 0.25% of Illinois FOID card holders actually registering firearms, around 6,141 of the 2.4 million. Again, that's 0.25%. So some say that's an extremely low registration rate, and maybe that's because, as we heard from the Southern District of Illinois oral arguments, maybe people are confused by the rules. Well, the rules aren't finalized yet. You had the emergency rules that are in place and proposed amendments to those rules taken up this week by the Joint Committee on Administrative Rules, but they did not act on those rules, so the amended rules are not in place. The original September 15th rules are still in place with all the questions that there are and all the pitfalls and holes that there are in those rules, so those rules are not in place, or at least clear enough for people willing to voluntarily tell the Illinois State Police they have banned items. So again, the governor talking about how, well, the people will wait until last minute to, get everything in order and to register. And he almost makes it sound like, you're studying for a test. Even that anecdote or that analogy was made by State Representative Bob Morgan. It's like cramming last minute for a test. This isn't a test. This is the possibility of people getting hit with a felony charge if they're found in possession of a banned item without telling state police they had a banned item. And that felony charge could lead to a loss of their Second Amendment rights, their voting rights, could lead to prison time. So this isn't like cramming for a test. This is a major issue of criminal justice in this state. So obviously there's all kinds of lawsuits that have been filed, right? So just to take a quick look at some of the status of these lawsuits, you've got the various cases that have been filed in the Southern District and the Northern District. The Northern District had a case challenging Cook County and Chicago's gun ban. You also had another case challenging Naperville's gun ban. Both those cases wrapped in the state's gun ban whenever it was enacted earlier this year. Those were in the Northern District. Federal judges in the Northern District essentially sided with the state, saying they had a likelihood of succeeding. In the Southern District, you had a whole bunch of cases that were consolidated where Judge Stephen McGlynn said that there's a preliminary injunction in place because he believed the plaintiffs had a likelihood of success. So while that injunction was in place, and then you had the Seventh Circuit Court of Appeals take all these cases, just as the Naperville plaintiffs were asking for the U.S. Supreme Court to intervene. But as the Seventh Circuit Court of Appeals was consolidating the cases from the Southern District and the Northern District with different outcomes into one set of cases that they were going to review, they signaled to the U.S. Supreme Court they're doing a rocket docket and they're taking care of it. So the U.S. Supreme Court at that time did not take the Naperville case. So then we had the Seventh Circuit hear that case, oral arguments. They deliberated that internally for 4+ months, and then they released a ruling early November, essentially vacating the lower courts in the Southern District's emergency injunction, meaning, the lower courts blocked the law from being in effect. Well, the Seventh Circuit stayed that, essentially saying that's not active right now. And then they ultimately overturned that lower court decision and said that the state had a likelihood of succeeding on the merits. I think that's important here. We have yet to fully deal with the issue of the merits of whether or not you can ban commonly owned firearms and require people to register those. Have not dealt with the merits on these things, even though it's gone all the way up to the U.S. Supreme Court. So after the Seventh Circuit's 3-judge panel ruled for the state, effectively, you had plaintiffs go to the U.S. Supreme Court in the Naperville case. But that wasn't the only case in the U.S. Supreme Court. That you had the Dan Calkins case out of the Illinois Supreme Court, where they ruled against Calkins on questions of equal protections under the law, because the law carves out police, retired police, active duty military, people in the private security space, prison wardens, jailers. They're exempt from having to register these firearms and actually can go and purchase these firearms, while the normal citizen does not have that right under state law. So that question of equal protection went in front of the Illinois Supreme Court in Dan Calkins' case. And Dan Calkins requested 2 justices recuse themselves. They did not recuse themselves, and that led to a complaint ultimately going to the U.S. Supreme Court asking about that. So you've got Dan Calkins' case here, which, we covered this to some detail, where the plaintiffs in the case, they filed for a petition to get in front of the U.S. Supreme Court. The U.S. Supreme Court essentially said that a response was due by the state December 14th. What is that? That's today. But instead, the state prematurely, ahead of the deadline, just went ahead and waived their right to respond, saying that they have no intention of responding. Then you had Calkins' attorney file a supplemental highlighting even more questions about the conflicts of interest and the political money that was involved there, and also questions of shared political outcomes of 2 Supreme Court justices that got political campaign donations from leaders of the other 2 branches of government. Then you had the Supreme Court Justice Amy Coney Barrett distribute Calkins' case to conference. All right, so they're going to actually take that up on the 5th of January. But then you had Calkins' attorney apply for a stay, asking for Justice Amy Coney Barrett to stay the law while this plays out. And you see here, this is the case designation, the docket designation for that stay request. But if you look at that actual designation on a different docket sheet, you could see that that application was denied yesterday by Justice Amy Coney Barrett. So while the application for writ to essentially stay the law pending the outcome of the case, that was denied. However, it appears that Calkins' case is still in play in the U.S. Supreme Court because it was distributed to conference. But that wasn't the only case in front of the U.S. Supreme Court. Even Governor J.B. Pritzker acknowledging that this is far from over. Earlier this week, he did acknowledge that this is going to be going all the way back up to the U.S. Supreme Court, and especially when we start tackling all the issues of the merits of this case.
The hearing today down in East St. Louis in front of the same federal judge who previously blocked the law temporarily. Are you concerned that he will step forward and block the registry from taking effect on January 1st?
Look, I'm always concerned that someone with a political agenda will make a decision that is inappropriate in this circumstance. I also know that this thing is working its way through the courts and likely will end up at the Supreme Court. So we'll have to wait for the final decision there. But I do believe that this law will go into effect on January 1 and that it will save lives across the state.
So the governor expects this to go into effect January 1st, but acknowledges that it's going to go all the way up to the U.S. Supreme Court. And it has gone all the way up to the U.S. Supreme Court. Again, the Naperville case, having already asked the Supreme Court to intervene at one point in this, did get some recognition from the U.S. Supreme Court recently with their second application for writ. So that was filed, docketed. Response was ordered from the state due by December 6th. The state responded. Then the plaintiffs responded. But you also have the plaintiffs telling the justice that the Seventh Circuit Court of Appeals denied an en banc review. So clearly a lot going on when it comes to these cases. But what about what we had heard on Tuesday down in East St. Louis? That, of course, was something we unpacked yesterday with the questions that the judge asked, the points that the plaintiffs asked, and that the defense as the state asked. So let's look at the docket sheet for the Southern District here. And you can see that they had the hearing where, let's go ahead and read this. The court's in receipt of 71 stipulation of dismissal filed by plaintiffs and a variety of others as the claims against defendants with prejudice. Courts. Well, this is an interesting docket. Make sure I'm on the right one here, just to ensure that we're set. So. McGlynn, motion held by Zoom. So yeah, that was Tuesday. Those were available. And then on the 13th, in regard to oral arguments conducted before the court, the plaintiffs requested additional time to respond. You've got the court adequately briefed on the issue of standing. And a memorandum of support of dismissing the case, reply to the motion was filed, oral arguments had. Should plaintiffs wish to address additional points related to all of this, they've got a deadline of Friday, December 15th. While the court understands that this is a short time frame due to the pending motion for preliminary injunction, the court requires all arguments to be submitted as expeditiously as possible. So even more documents are going to be filed before the end of the week here in the Southern District case. And then it says to strike that order. Okay, let's strike that order from receipt of number 71, and that's this docket entry. And I'm just now seeing this morning live, so kind of digesting this with all of you as well. And you've got plaintiffs' claims against the defendants in the village of Glen Carbon dismissed with prejudice. The clerk of the court's directed to close this on the court docket. Okay, so that's an interesting. I'm going to delve deeper into that. But then it goes into some other issues that were filed on the docket sheet yesterday, including the transcript of the hearing. So if you want to get a transcript of the hearing, you can do so by contacting the court. But again, the judge also setting a deadline for response to the motion to dismiss. The plaintiffs have a response that's supposed to be due by noon on the 15th. So, again, when it comes to the Southern District of Illinois, you had Judge Stephen McGlynn say he's inclined to not grant a preliminary injunction delaying the January 1st deadline for people to register banned items with state police. But he did say he hasn't made up his mind. So will we see that decision come Friday? It's quite possible. So that's some of the latest happenings here when it comes to the cases pending in court, because there very much still is a lot of action to be had just on all of these preliminary motions. This has nothing to do with the merits of the case. And I think that's what's interesting here is you've got plaintiffs that have asked for immediate relief, saying that they're harmed by not being able to exercise their Second Amendment. And they're being harmed by either having to get rid of their firearms because they don't want to register. They're being harmed by not being able to go purchase firearms because they're banned by state law. And then you've got the prospect of people possibly facing criminal charges, felony charges, and the loss of civil liberties by facing those criminal charges. So a lot happening, and we'll continue to track this and more as all of this plays out, including all of the arguments that are going to be had in the Southern District. And I'll drive down there whenever they have these arguments on the merits of these cases. So a lot happening. It is Bishop on Air. Thanks for hanging out every weekday morning. Like, subscribe, hit that notification bell, and follow along on X, on Facebook. And you can stay up to date with all of this and more. All right. It's Bishop on Air. More coming up.